Right, the first case to come before the court this morning is State of Ohio versus Kyle Cooper. Mr. Mednick, the state has waived, so you will have your full 15 minutes if you choose to take it. The arguments being visually and audibly recorded to be posted online. Please keep your voice up, remain behind the podium. You should not use the names of any children or minors or victims, although I don't think that's applicable to your argument or your case. And we have read your briefs and we are ready to proceed. If you are, I will be keeping time, but as you can see, you can watch it for yourself also.
Thank you very much. May it please the court, I am Alan Mednick. I am here representing the defendant and appellant Kyle Cooper in this matter. As you've read the brief, this involves a question concerning a negotiated plea and subsequent indictment on a felony arising from the same fact. Let's start. I was in the municipal court like 2 weeks ago, and on an initial appearance to the floor when the municipal for a felony charge. At that time, the municipal prosecutor approached me and said, we would like to resolve this matter as a misdemeanor. Obviously, I went back and negotiated that process with my client, and we resolved that matter without this ever being indicted, without it ever going to grand jury, without there being any involvement from county prosecutor in any way, shape, or form. My client, the prosecutor I found, who presented that offer, I think has every belief that this matter was resolved, and as do I. It's not an uncommon practice. This is not a rare occurrence. This is not unusual. I don't need to get the authority of a county prosecutor to resolve a misdemeanor prior to its indictment. And that, not just common practice in this court, I think as was indicated in the Sims decision, in this district, in our municipal courts in Summit County, but also it is embodied in the law that these municipal courts have authority and jurisdiction to resolve such matters at that level. They are not devoid of handling any jurisdictional issue. They don't lack jurisdiction to handle a felony. They have limited jurisdiction, and that jurisdiction terminates when it goes through a grand jury. They can resolve a case as a misdemeanor at a preliminary hearing if the facts don't support it. They can dismiss the case. They can bind it over for grand jury indictment. Those are all authorities that this court had, and that this court had in this matter for Mr. Cooper at the time that Troy Reeves reached the negotiated plea in this matter. Attorney Reeves knew and understood that. He's been an attorney for about 20 years and worked in this jurisdiction for, I think, all of that time. I think that he made a reasonable representation to his clients that this was intended and meant to resolve all of the matters in this case, and I think the prosecutors understood that, and I don't understand why it ended up indicted and he ended up with further felony charges subsequent to that plea agreement being out. With that said, additionally, the other part of this that is somewhat trying is that the city of Akron and the county of Summit are not separate sovereign entities. They are all subdivisions of the state of Ohio, and they're all working as part of the criminal enforcement of that state. That there was a city prosecutor who presented this plea and then a county prosecutor who brought the subsequent indictment. And also as part of that process, I can tell you that that same indictment would have gone through the same bind-over process and been handled and touched, and I checked the record and was touched by a municipal prosecutor. The initial appearance was handled by the same parties who were involved, the same office who was involved in resolving this first, the OBIs, as a matter of negotiated plea. The division of labor, division of jurisdiction presented in this case is artificial at best. There is one state entity. These are both brought as state charges under state statutes, and they were resolved by state authority. And to parse this out in that way, to subject Mr. Cooper to further prosecution when he reasonably believed that he was resolving the entirety of his matter, is unreasonable, and I think the court erred in finding that he did not reasonably rely on that plea as a resolution of all cases, to all charges arising from this matter. The primary cases relied upon here for creating this this precedent are all cases involving, this would be Zima, Dye, and Carpenter at the Supreme Court level. They all involve felonious assaults that subsequent to the plea became homicides in one way or the other. That at the time that the plea was entered, there was a subsequent set of facts that arose. That being that the victim of the felonious assault, the victim of the vehicular assault, died. And those charges that were subsequently attempted to be brought, and in the case of Zima successfully brought, were all cases that arose subsequent to the plea. Here, there are no circumstances, no facts that were not present at the time of the plea. Every action that was raised in the second indictment was present in the first complaint. That all of that information was there. The officers that were involved were identical. The officers that signed the complaint in both cases were identical. I believe it's probably the same officer who represented to Mr. Cooper that no subsequent charges would be brought. So that is a distinction of note in these cases, and which is analogous, and I point in both my brief and my reply brief to the McDonough case out of the 8th District, which is absolutely on point, and I believe almost identical charges, where a defendant pled to misdemeanor charges and on the same facts was subsequently charged. And based on those facts that I just articulated, the fact that there was no separate set of actions, that there was no separate set of circumstances that arose, and there was an identity of actors in both cases, the earlier plea was dispositive of the later charges, and those charges were dismissed. I would ask the court to point to that. Additionally, I would go back to even the Zima case and the Carpenter case, where the language that is articulated in those cases, and Zima is distinguishable because in that case, the felony charges were already indicted. They were already present and not addressed by the Munich Court plea. And it's not an issue that generally arises here in Summit County because all of our misdemeanors are bound over along with our felony charges. But that's not the case in every county. And so while they were traveling on these parallel tracks, the defendant in Zima resolved the misdemeanor cases without a clear determination of the felony charges. Those were already pending. They were not present in this case. And that's not a factor that is present here.
And how about State versus Sims?
State versus Sims, I'm going to be upfront. I don't have a strong response to that outside the fact that I think Sims was wrongly decided. I think it's in, and I would ask if this court is going to rely on Sims, that this court certify a conflict between the 8th District based on the McDonough case. I believe that the representations there, as I've indicated, minimize and miscast the relationship of the county prosecutors and the municipal court's authority and jurisdiction. I believe that there's an error in its assessment there. I'll be upfront about that. I don't like to, I understand that that's a matter of stare decisis here, but there are instances in which precedent is to be reconsidered, and I believe that that is the case here. That I think that case, the body of work and the body of precedent of how cases are handled here and how a defense attorney would resolve a matter in the municipal court here is thoroughly undermined by the Sims decision. Even in because as I said, in the cases that I have resolved, I don't have to go to a county prosecutor to resolve that case in its entirety. When I reach a case conclusion before it comes over to grand jury, the only person I'm talking to is a municipal prosecutor. That, I don't need an acknowledgement from the county prosecutor, I don't need, they may have those conversations in the background, sometimes they indicate that they do, sometimes I don't know. But in this case, a municipal prosecutor and the municipal court have the authority to reduce those charges and to dismiss them or plead them out as misdemeanors.
Just so I understand what happened here, was there actually a reduction or he was never initially
In this
charged?
case, the felony charge was brought subsequent to this plea. I
Okay.
am not trying to make, but I'm not sure that I would argue that's a distinction without a difference and would lead to procedural measurement. That it would not, it could open itself up to an abuse that is unnecessary. I think that, and again, these charges could have, and I'm not quite sure why they were not brought at the time. They certainly could have been. There was no separate set of circumstances that arose. There was no further injury. Everyone knew everything that had happened prior to the plea here. Even if that were not the case, there is no indication in the record that the prosecutor reserved the right to bring later action, and that which is a necessity. It's not just that the reliance of the defendant be reasonable, but at the time of the plea, the prosecutor would need to specifically set aside the opportunity to bring further action based on the facts.
Which prosecutor, counsel?
What's that?
Which prosecutor?
In this case, there's no distinction between who that prosecutor would be. All of the cases here, in this case here, commenced in the Akron Municipal Court. The case that the aggravated vehicular assault commenced as a municipal case that was bound over bound over grand jury after initial appearance at the municipal court level. So the distinction between these prosecutors' offices is slim at best. I mean, once it reaches the felony level, I would absolutely argue if this case had been brought and was up here, then by some set of circumstances there was a misdemeanor case, and this case had been pending after grand jury, absolutely they need to talk to the county prosecutor, and that's what would have been done. And I believe that all of these cases would have been up there. I believe Attorney Reeves acted quickly and responsibly on behalf of his client to try to resolve this quickly. And finally, and I don't think that there was any doubt in anyone's mind, and I would include the municipal prosecutor in that debate, that this was to be a complete resolution of the issue. Again, and to that point, there is a presumption, and that is stated in Zima, that there's a presumption that these cases, that a plea is to be final. That is a rebuttable presumption. That is the state's burden to rebut that, and I don't know that they have, and I'm not sure that that's how the trial court approached that issue. That the language of the case is specific, that it's the burden of the state to rebut that presumption. I would point, I'm sorry.
Counsel, that's okay. Do we have a full record from municipal court?
No, and I have not been able, I reviewed it, I have not gotten certified copies, and I will move to certify that record over here.
Was that in front of the common police court?
What's that?
Was it in front of the common police judge?
Which,
Well, you're talking about what happened.
the
with-
municipal court
Yeah.
record, I am unclear if it's fully in the record here. I know that they had trial testimony, I don't know that they presented. I myself have reviewed the municipal record, but I don't know that it's fully reviewed.
Thank you.
And finally, I would point, again, back to the Zima Carpenter Dye line of cases. Those cases commence and rely on language out of the New Hampshire case, State versus Gordon. That's 116 NH 479. And the quote from that is that the prosecutor knew the facts on which the present charges are based at the time the defendant pleaded guilty to the initial charges. Nothing prevented the prosecutor from seeking the present indictments. Then, the submission and acceptance of the defendant's plea must have contemplated that no further charges would be brought for the defendant by his plea has deprived himself of any meaningful defense to the present charges. That is language that is quoted in Carpenter, that it's the basis for their decision going outside this district, and that is also the exact facts that arose here. There's nothing in this case that the prosecutors did not have in front of them at the time of the plea, and to have not indicted at that time, and then go back for a second bite of the apple after they have received a defense plea on other charges and put my client in a worse position is untenable. With that, I have about 15 seconds left, so if there's anything else. Thank you.